Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Natalia Angelini.
And I'm Gray Wen.
Welcome to Hull on Estates. You are listening to episode number 710. Today we're going to be discussing the case of Tesaro and Gora. It's a very recent decision from January of this year involving two negligence actions against a drafting lawyer and a summary judgment motion brought in defense of those claims, seeking their dismissal. So the outcome is very interesting and we can dive right in.
Okay, so I'm going to discuss about the facts. So in this case, the deceased passed away on July 16, 2018. In 1991, the deceased retained a lawyer named Mr. Gora to draft his will. The will was signed on November 6, 1991. The will contained ambiguous language regarding the division of assets among his beneficiaries, creating uncertainty about whether the nieces of the deceased, which is the daughter of the predeceased sister, were entitled to a share of the estate. So what is the ambiguity in the will? The will stated, "To such of my sisters living at the time of my death, I give whatever real estate that I own or that may be in my possession at the time of my death in equal shares per service." This language caused confusion. The first one, living at the time of my death, suggested only surviving sisters would inherit. Number two, in equal share per service implied the deceased sister's share might pass to her children, which is the nieces. So the beneficiaries. The deceased was survived by two sisters, Irene and Virginia. A predeceased sister, Monica, had two daughters, Kim and Lynn, which is other nieces. They claimed a share of the estate as descendant of Monica. So, the legal proceeding. In 2019, the surviving sister sought a judicial interpretation of the will, initiating litigation determining whether the nieces were entitled to inherit. The nieces filed a separate lawsuit on December 24, 2020, alleged that Mr. Gora negligent drafting of the will custom financial harms. So this case actually was settled. However, there's another issue, which is regarding the limitation period.
That's right. Right. And so in a nutshell, it's interesting because it seems like a pretty typical, I guess, scenario where there's an ambiguity, right? Do the two surviving sisters take versus them plus their nieces? And there's a negligence action brought against the drafting lawyer, but the drafting lawyer, quite, I guess, astutely decides to bring a summary judgment motion and makes the argument that, look, the will was drafted in 1991, and the ultimate 15-year limitation period applies, and you're outside of that time frame. So, the actions against me are statute barred. Right, Graham?
Yes.
And the court, I could see from reading the decision that His Honor did a really thorough review of, both positions and the arguments made, and looking at the limitations statutes and what was the purpose of the ultimate limitation period, right? Why was it put into place? What is its language? And really considered all the arguments, but ultimately felt bound by that language, right, Gray? The language that said the limitation period it starts from the act that caused the negligence, and that act, in His Honor's view was the drafting of the will in 91. So those 15 years are calculated from, well, not from that day, right, Gray? From the 2004 day?
Yeah.
From January 1st, 2004, because of the transition provisions in the statute. And
Yeah.
so even starting in 2004, the 15-year limitation period was still beyond that time frame.
Yeah.
So, did you have any thoughts that came out of this decision, Gray? Because I expect it's going to be quite a controversial one.
Yeah, I think this decision really underscores the strict application of statutory limitation period, even when the result in harsh outcome for plaintiffs, right? It highlights the need for the beneficiary and their representatives to act promptly when pursuing legal remedies, and suggests that legislative reform may be required to address the unique challenges faced by the beneficiary in will drafting negligence cases. So, yeah, that is my opinion regarding this case.
Yeah. I mean, and legislative reform may be needed. We'll see if this case is appealed and what that outcome will be. But it certainly there's certainly a dilemma here, right? Because if someone drafts a will 20 years ago, 30 years ago, but the testator doesn't pass away for another few decades, this kind of decision, or the law being as it is problematic for beneficiaries, because they may be unable to pursue claims before they even know that they're beneficiaries, right? Because a will speaks from death. They're not necessarily going to know until after death of the testator that they've got an entitlement and a potential claim. So it is quite a draconian and harsh outcome that His Honor recognized. It is the harsh outcome. And he also looked at, the whole point of an ultimate limitation period is to stop the clock at some point, to avoid, not just unreasonable claims, but also, good claims, because there's public policy reasons for that, right? Do you remember some of the public policy reasons His Honor mentioned? I think he mentioned, a person has the right to, at some point in time, after passage of time, to be able to rest assured and know that there aren't going to be claims brought against them, right? It brings certainty, finality. It avoids other problems like evidence gathering that can be more challenging when you're 10, 20, 30, 40 years down the road, right?
Yes.
So it's very, very interesting. I know our bar is going to be, or I expect our bar is going to be carefully watching where this case leads, if it continues in the system, and or if there's going to be any legislative change as a result.
Yeah.
So did you have any other thoughts about the case to share?
I just think this is really interesting case, and I'm looking forward to see what this case will be developed to.
Yeah, me too.
Yeah.
Well, I think that concludes our podcast then. Until next time, thank you for listening. I'm Natalia Angelini.
I'm Gray Wen.
Should you have any questions, please email us at info@hullandhull.com or contact us through the contact page on our website.
Thank you.
Thank you.
Have a good day.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.